Hello and welcome to Rathod Science Academy. So we are going to see a very important topic in this class. It is about Supreme Court verdict on subclassification of scheduled caste and scheduled tribes. It is one of the landmark verdict of Supreme Court in 2024. So this topic is very important from both your prelims and as well as mains point of view. So let us haunt this. What is the Supreme Court judgment and what are the roots of this? So when it had been started, so what are the series of cases? And whenever I'm talking about cases, you have to remember those cases names and along with the years. So actually why this is landmark? Because in 2024, so this judgment of Supreme Court had been reversed the judgment which is given in year 2004. So in 2004, same Supreme Court gave a judgment in the famous case called as A.V. Chinnaya versus State of AP. So in this case, Supreme Court cancelled one important thing, that is about subclassification of scheduled caste. So actually what AP did was AP came up with this subclassification of SCs. Then what happened? So this had been challenged in Supreme Court in year 2004 and this had been now cancelled by Supreme Court in 2004 judgment. So Supreme Court said that whenever there is subclassification for reservations in this SC which is violating Article 14. Article 14 says about right to equality, and within this community of SC, whenever we are treating differently the people based on the subclassification, then it is violating Article 14, that is about right to equality. So we can't do that because historically this SC people, that is scheduled caste people and scheduled tribe peoples, they face disadvantages from history onwards. So now again when you are treating them based on the subclassification, it will be violating this Article 14. So because of this, this had been cancelled and said null and void by the Supreme Court in 2004. But what happened in this 2024 judgment was, so this judgment of 2004 had been overturned here and Supreme Court now gave the permission for sub-classification of SCs and as well as STs, and this is only the first point. So first point it said that yes, now we can go for sub-classification in this SCs and as well as STs. And apart from that, now it also said that state government have the power to go with sub-classification. Okay, so these two things are given. So you may ask me a question like on what basis Supreme Court gave this judgment, right? So if this is your question, then the answer for this question is, so based on Article 16 subclass 4 and Article 342 subclass 2, it gave the decision. On this Article 16 subclass 4, it says that yes, state can take some affirmative action. Okay, it is not saying that entire ST community or SC community should be taken as equal. So here it is saying that if they are not adequately represented. So this Article 16 subclass 4 says that if that community is not adequately represented, then government can take some affirmative action to provide reservation for them. And this same article is not talking about equality. That means all people in this SC should be equally treated. So on this basis, yes, we can go for subclassification now. But earlier judgment said only on Article 14. But now this 2024 judgment is saying about Article 16 subclass 4. And next one here is, earlier Supreme Court said that we have Article 341 and this Article 341 gives exclusive power to the president. It is not the power of state to come up with subclassification. But now this 2024 judgment is based on this Article 342 subclass 2, which says yes, states and as well as UTs, they have the power to come up with this classification of SCs and they can come with a separate list of SCs apart from president list. So this is the present judgment. And let us dig deeper and let us see this judgment of 2024. So it is 7-judge constitutional bench. Now it decided the case. And now what are the highlights? As I said, the first one is it allowed subcategorization, and next one is it allowed wider protection of this unrepresented groups in this SCs, and even they are talking about especially this can be done for solely the reservation. Reservation in what? Reservation education first thing, and reservation in employment opportunities. So this is the present judgment. And if you see the roots of this case, so we have to go back to 1975. In 1975, what happened? Punjab state government came up with one notification, and in this notification it says 25% of SC reservation is divided into two categories. So first category includes only two groups of people. First one is Balmiki and second one is Mazhabi Sikhs, and in the second category other rest SC community will come. So actually why they came up with these two categories, because so these two subgroups, they are very underdeveloped both economically and as well as educationally. So whenever they are talking about reservation, the first priority in case of employment and in case of education, reservations will be given to these two groups first, and later on they will be giving priority to the other SC community in Punjab. So this is in year 1975. So later on, what happened in the same way, AP government also came up with this type of legislation or law. That law is AP-SC Rationalization of Reservation Act. So it came up with subcategorization of SC community, and this is the present case of 2004. So that case is E.V. Chinnaya versus State of AP of 2004. So whenever you are writing the Supreme Court judgments, you have to write this case's name along with the year as well. So in that way only you can get the good marks in polity. So in this case, what Supreme Court said is, it is against Article 14, it is against right to equality. So within the same community, we should not treat differently because it is violating this Article 14. And even it said that it is the power of president which is given clearly in our constitution under Article 341. So state should not interfere and state should not come up with the list. So this is the thing which mainly said in this 2004 case. And later on, what happened in 2006, one more case, that is Dr. Kishan Pal versus State of Punjab. So in this Punjab, already in 1975 they came, no? So after that, what happened in 2004, Supreme Court had been stuck down this AP's law. So again, what happened in Punjab also, that law is going on. So here in 2006, that same notification of 1975 has been challenged. So already Supreme Court gave judgment in 2004. So they followed the same judgment and they stuck down this 1975 notification of Punjab government. So as of now, till 2016, there is no subclassification of SCs in either AP or in Punjab. Then what happened? Just within a matter of 4 months, so Punjab government came up with a law. Anything which is present in law, it cannot be stuck down, right? So here Punjab government came up with this act, and that act name is Punjab SC and BC Reservation Services Act of 2006. So this act is following the same past 1975 notification. So it is talking about reservation for two communities, Balmikis and as well as Sikhs for the first priority, and other SCs are given second priority. Same that thing came up in a new act name, that's it. And later on, this also had been challenged in Supreme Court. In 2010, it had been struck down. So here it tried to divert the judgment of Supreme Court. It came up with the law. So now Punjab government understood that no, it will not happen. So directly Punjab government went to Supreme Court in the case called as Devendra Singh versus State of Punjab. And in this Punjab, they see these two things like Punjab government notification and as well as AP's notification, and even they are seeing this 2004 judgment. And here in this case, something interesting happened. So in this case, what happened here is, Supreme Court said that, yes, whatever you are saying is, there is some sense that I can understand here. So it disagreed 2004 judgment, and it said that in that same caste also, all people, they are not moving equally. Some are rich and some are like poor. So exactly this poor people needs to get affirmative action from government. So we can go for sub-categorization, but that is not a final decision which is given in this judgment. And later on something interesting happened, and in 2018, and this, 1 minute, I have to show this. So this Devendra Singh versus Punjab case was in year 2014, and it was not a final judgment. This just what happened in that case is Supreme Court just it disagreed about this 2004 judgment, but they want to refer this judgment to the larger constitutional bench. And later on in 2018, what happened was Jarnail Singh versus Lakshmi Narayan case, Lakshmi Narayan Gupta case. So in this case, Supreme Court said yes, we need creamy layer. So Supreme Court upheld creamy layer, and because of that they came up with income ceilings for reservation. If you want to get reservation either in employment and as well as in education, you need to have income ceilings. Based on that they can implement this creamy layer, and for the first time in 2018 they applied this creamy layer in promotions, not in employment or like providing employment or providing seats for education. Just for promotions they implemented in 2018. And later on, now in this 2024 judgment, it took article 16 subclass 4 and article 342 subclass 2 and gave the judgment of yes, now states they have the permission to come up with subclassification in this SCs. And next one is yes, this article 16 is talking about reservation, but here reservation cannot be provided for everyone. Only the group which is inadequately represented they can get the reservation. So this is the final judgment of 2024. So now let us see something interesting, like what are the advantages of this subclassification of this SCs and STs and what are the disadvantages. So you have to know this. So what will be the advantages? So first one is equitable distribution of benefits. So in that group also we have rich and as well as poor. So poor will be getting benefited now, right? And next one is we can give the support to the targeted people only who need actually the support from government, they will be getting. And next one is even it will be helpful for reducing inequality in that so and so society. And next one is it will be helpful for inclusive development, because nowadays the problem here is only the rich people or so called as advanced group in this SCs, they are grabbing all the opportunities. So because of this the case had been filed, we need subclassification, so that whenever we are including this underrepresented or very underprivileged people means we can ensure inclusive development, and even we can enhance the representation of these people in policy making in everywhere. And next one is we can focus on most needy, especially we are prioritizing marginalized societies. Okay, so these will be the advantages of subclassification. And now tell me, what are the disadvantages? So first one is, for saying it is very easy to me and to listen to you, but it is very difficult in implementation because we need different data, income certificates, caste certificates, in that again subgroups. So from past 2 to 3 generations we need to have that. So implementation will be very great challenge, and even now within the community also there might be increasing of tensions between the same community, and even sometimes India is very much famous for red tapeism, nepotism, whatnot, corruption. So here there might be politicization, and especially in our India, vote banks politics will be going on. So based on caste, they will be going for campaigns that will lead to populistic measures and as well as further more politicization. And next one is even we are having legal and constitutional challenges. So this is about this topic, and I hope this topic is very useful for you, and even you understand what are the roots from 1975 with the similar cases. So if you are knowing this knowledge in this detail, then you can easily write an answer for this question, and this will be very, very useful. And I hope this is at least 10% of people who watch this had gained some knowledge. And if you like this video, please hit the like button, and please do subscribe to our channel and do share this video to your friends. Thank you guys.